Welcome, everybody, to another episode of the Good Deeds Note Investing podcast. Hope you're all doing well this evening. I am Chris Seveney, your co-host, and Gail Anthony Greenberg wasn't able to join us tonight. But tonight we have a special guest, a follow-up from a guest we had prior. We got Tony Sottile from Sottile Barile, who is going to be talking about common mistakes made in bankruptcies and doing a little deep dive into Pacer. Tony, how are you doing this evening?
I'm doing fantastic. How are you, Chris?
Good. So tonight, like I said, that's what we're going to be talking about. But I'll give Tony in a minute to introduce himself. And one question I had after you introduce yourself, Tony, is just out of curiosity, if you've seen an uptick in bankruptcies, or if basically they've stayed pretty flat lately. Just curious about that because people hear about a lot of consumer debt. But before we hop in, that was on my mind. I'd like to, again, let you introduce yourself to everyone and go from there.
Perfect. That sounds great. So, hello, everybody. I'm Tony Sottile with the law firm of Sottile Barile. We're out here in the Midwest. We've got offices in Cincinnati, Cleveland, and Chicago, Illinois. And we practice in Ohio, Kentucky, Indiana, Michigan, Illinois for everything. So that would be bankruptcy, foreclosure, eviction, forfeiture, all of that, collection activity as well. Then you can add the states of Wisconsin, Colorado, and Washington, D.C. for just bankruptcy only matters. And then we practice across the whole country for certain bankruptcy matters. So like they're called limited access filing matters. So proofs of claim, transfers, claim reviews, with all 94 jurisdictions. I'm very proud to say this is our 5th year of operation. So that was quite an exciting moment when we realized this was our 5th year, and going strong and plan on going strong for many more.
Good.
So to answer your question, Chris, I think first of all, we're kind of in a downtime of new bankruptcy filings anyway. Bankruptcy filings are pretty much at their lowest from December through February in terms of new filings.
Okay.
And then it's kind of a race from March to October, November, and then again it slows down around the holidays. And then nobody has money to file bankruptcy because filing bankruptcy, believe it or not, costs a lot of money. These debtor attorneys charge quite a bit of money for bankruptcy. So they don't have any money until they get their tax refunds, and they got to spend their tax refunds down. And then they start filing again in February and March. So we're going to pick back up here. Year over year, though, we are up from where we were this time last year. So I think you are starting to see an increase of bankruptcies again as people spend more money because the economy is so great, and then realize that they can't pay back some of the debts. They're in bankruptcy. So I'm seeing more and more, and it will continue to rise, I believe.
And I would think with housing pricing increasing and people's personal spending increasing, you'd kind of see more of a rise in bankruptcy because people would want to protect that house that may have the equity. Whereas if there's not as much equity, people may just try and, avoid the bankruptcy and just try and give the house back to the bank. Yep. And to avoid it, correct?
Yep, that's exactly correct. That's exactly correct. And how much they make kind of depends on which chapter they can file. If they're relatively lower income, generally Chapter 7 is the way to go. If they have a little more income, a little excess income, just not enough to pay all the bills, or they've got some real estate they want to keep, they're in arrears on it, that's when you find people filing the Chapter 13s. And a lot of 11s. A lot of people are filing 11s these days. So
good.
You'll see all of it.
So I've dealt with 7s and 13s, mostly 13s, not really too many 7s, but the 7s I've had have kind of had some hair on them, to say the least. But, filed 7s, no reaffirmation agreement, and then borrower kind of keeps paying, and then you're quiet alone. It's like, okay, servicer, now what do? I can't talk with them because they, discharge. So how do you go about it? But why don't we, I'll turn over to you and let you, I know you got a presentation for everyone, and for people listening to this episode, we will have this up on YouTube, and our Facebook group, the Notes and Bolts from Good Deeds Note Investing Podcast, will be up there live as well. So you'll be able to watch it from either of those stations. So I'll turn it over to you, Tony.
Perfect. Thank you. So, like Chris was saying, this is kind of a continuation of part one that we did in October of last year. We did kind of an expanded 101. We did a lot of kind of small topic discussions on different pleadings and different costs, things to look for in a bankruptcy. Kind of the nuts and bolts on the Notes and Bolts show. So we wanted to do something a little bit more advanced this time. So there'll be kind of some high level overview of different pleadings. That's really not what we're going to talk too much about today. I don't really want to get too bogged down with that, so we can make sure we cover some of these other things. But if there are questions, please make sure to ask, and we'll try to get them answered along the way. I don't want to confuse anybody. So, but this is definitely not really a beginner level class. This is, or a podcast rather. This is a little bit more kind of sophomore, junior level kind of stuff. So, I wanted to talk a few things tonight about common mistakes that we see the note buyers making these days, and that wasn't really enough to fill a whole kind of class. So we wanted to throw in a deep dive into PACER. So. Let's go right into some common mistakes. So, common mistake number one is not taking the time in your due diligence process. So some of you do your own due diligence, some of you farm it out. Obviously, whether you're doing it or somebody's doing it for you, you want to make sure that you're reviewing anything that you get in. You want to make sure that you're looking for bankruptcy information, because that's obviously going to be a big part of your decision-making process and whether or not you end up buying the note or buying the pool or whatnot. Look for bankruptcy pleadings in that tape. Look for any kind of jurisdiction or case number that's on them. Most pleadings are going to have a case number and a jurisdiction on them. See if documents like that are within the materials that you're able to take a look at. Sometimes, and I know that this doesn't happen all the time, but sometimes you're able to get a social security number. That's gold, because then you can go and just put that person's social security number in PACER and do a national PACER search to see if they've filed any kind of bankruptcy. That's your best bet. Your best bet is to get a social and run it through PACER.
Yeah, because when your borrower's John Smith, don't even bother trying to search.
Don't even bother. When we go to the PACER side of the session today, I'll show you a couple of different ways you can search. But Chris is exactly right. If your debtor's name is, John Smith, don't even bother looking on PACER. But if it's a very unique name, you may not need a social security number. You can't search by property address or a lot of the stuff that you would think you might be able to search by. You need a debtor's name, you need a social security number. So hopefully you have that. If not, hopefully you can find some pleadings in the tape that you're reviewing, and that'll kind of give you a clue whether or not you're also dealing with a bankruptcy at some point. Read your servicer notes if you're able to get the notes on these, because sometimes there'll be a little nugget in there that the servicer took a call from the debtor that says that they filed bankruptcy. Even if you've got the bankruptcy case number but not the jurisdiction, you can probably get close to the jurisdiction by the property address.
Your audio just went pretty wacky. I don't know if anyone else can hear that. It sounds.
Are we better now?
Yep, there you go.
Okay. So check out these servicer notes, right? So sometimes the debtor will call in and and tell the servicer that, hey, I filed bankruptcy. Here's my bankruptcy case number. You may not get the jurisdiction, but you can probably get the jurisdiction from where the property address is. Most people are filing bankruptcy where the property is located. Most of these folks only have, one property. So read the servicer notes. That might contain some useful information. See what was already done on that file. See what the intent of the debtors is. So if you do see that they've filed a bankruptcy, and we'll talk about some of these pleadings and some of the things to look for on PACER, but see what's already been done in the case. See what the intent of the debtors was, or the debtor was in the case. Do they want to keep the property? Do they want to surrender it? Consider having an attorney do a post-petition file review if you're not comfortable. If you see that they've got a bankruptcy on record, Get with your bankruptcy attorney, get with us. We can take some time with you and we can review that file, or at the very least, the bankruptcy part of that file. I mean, that's what we would do. We would review the bankruptcy part of the file and tell you where that case is, tell you what's going on, tell you if money's coming in. You should know some basic timelines. A Chapter 7's 3 to 6 months. A Chapter 13 is 3 to 5 years. So if you're doing your own due diligence, kind of have some common bankruptcy knowledge. Google can be your friend on a lot of this. Know some differences between the chapters, and getting help obviously is pretty imperative on this. So have an attorney look it over for you, or maybe check out some previous presentations. The one we did in October, Chris, is good for a lot of this stuff.
Yeah.
And then, go ahead.
I was gonna say one thing I'll mention before we hit that last thing is, because this is important, and you mentioned social security numbers. I wholeheartedly agree with that, because not only are you reviewing for bankruptcy, but also how many bankruptcies. Because you may have a serial filer and who keeps filing, filing, and the lender might have been a hedge fund that just hasn't taken the time to try and beat them to the punch, and that can really cause you to expend a good amount of money trying to fight it and beat to the punch, which goes into what Tony's last item on this one is,
which is price your offer with all of this in mind. There are a lot of investors out there that love bankruptcy loans because they understand bankruptcy, they understand it in and out, or they know where to go to get the information, and they've got a good network of people that can help them take a nasty bankruptcy file and maybe spend some money, but be able to prevent that debtor who's filing on the eve of a foreclosure sale every time, be able to file the correct pleadings to get that debtor to have to stop. You can file pleadings with the court to basically put a chill on that debtor from filing bankruptcy for, potentially 180 days, a year maybe. And that's more than enough time in most jurisdictions to get a foreclosure through, especially since it's probably already started. But if you can get that price down pretty low, the few $1,000s in attorney's fees that you're looking to do all of this, you may still come out very far ahead. So just price your offer with all of this in mind, and don't run. Bankruptcies, it's definitely a part of your due diligence process, but it doesn't need to be the kiss of death unless, that's your deal. You just don't like bankruptcy files, and there's plenty of folks out there like that too.
I'm the opposite. I love them because, you get to see how much the borrower makes. You understand that. You can see the loan and get an understanding of what their arrearages are on the loan, and they basically need to be pretty much confirmed. So it's not like the total payoff is something that somebody just made up. It's something that is, I'll say legitimate from that standpoint. Yeah. And it's a controlled environment, and it's controlled federally versus locally. So, I know people, have issues in certain states, including myself, because of, judges may be more liberal, or, depending on the state, bankruptcy, that's a federal court system. Now, they still may in certain areas be a little more liberal than others, but typically they follow pretty much the same guidelines, I would think. Wouldn't you agree, Tony? For the most part?
Yes. Generally speaking, you might have, jurisdictions or judges, like you were saying, that are a little more debtor friendly, a little more creditor friendly, but your local attorneys will be able to help you. Oh, we drew Judge Smith. Oh, he's pretty aggressive on these. Maybe we want to give it a try, or, oh, this judge, there's no way we're going to get this through with this judge. Yep. So engage your attorneys.
Okay. Number 2.
Okay, common mistake number 2, reviewing the bankruptcy plan in light of the maturity date on the note. Okay, so this is another area where we see a lot of mistakes being made, and it's not just the smaller note buyer and the smaller note investor. It's the institutional clients that we deal with as well. So here's why knowing when the maturity date on the note is important, because there could be a balloon payment due during the case. Okay, so if that debtor is not addressing that balloon payment within that bankruptcy case, that case is destined to fail. And you need to know that, if you can, know that going in. If there's a balloon payment, make sure it's addressed in the bankruptcy plan. Another reason why this is important is because generally first mortgages on residential property, so this is the property that the debtor's living in, they can generally not be modified, but if that loan matures during the bankruptcy, it can be modified and the interest rate can be crammed down. So you may be looking at a note that you might be able to get, according to the face of the note, 10, 12, 15% interest. But if that note comes due during the bankruptcy, they can cram that down to a lower interest rate.
Did not know that.
And yes, only if, and this is so rare, so this is why it's not very common, but it is a mistake that we see made, and again, you're not typically dealing with such large interest rates anyway, but if we want you to get what you're paying for. So if you think you're paying for a note that's going to, get you 10% and it's due during the bankruptcy, it matures during the bankruptcy, don't even worry about the balloon. Say there is no balloon, it just matures, it's over with. You may not be getting what you bargained for. So that should also be part of your due diligence process, is knowing when that note matures. And if they're in a bankruptcy, that should cause some alarms to go off. Was that maturity addressed in the bankruptcy? Is there a balloon payment due somehow as you're looking at the note? When is that balloon payment due? If that's due during the bankruptcy, was it addressed? You should also know that if you've got a note already, if you've purchased a note and that loan then subsequently goes into a bankruptcy, all of this still matters. So it's not necessarily a loan that you're looking to buy, but if the note you already own then goes into a Chapter 13, make sure, as you should do on every Chapter 13 bankruptcy, make sure that you've got an attorney looking at that, performing a review of the bankruptcy plan, and putting together a proof of claim.
So I was going to ask this question because a lot of servicers will do the proof of claim for you.
Sure.
And, again, the question I get asked a lot is, should you have your servicer do it and have an attorney do it? I usually tell people, have the attorney do it. And I know you're a bankruptcy attorney, so you might be a little biased in that, but would you agree with that component? And probably because of the next thing you're going to talk about is why I'm guessing you probably would want an attorney to do it.
Sure. I would recommend you have an attorney do that for several reasons. One, that attorney is probably a little more versed in filing proofs of claim. They're probably going to charge you the same amount. Proofs of claim, they're generally the same price, no matter who's doing them. Most attorneys you're going to see are following the Fannie Mae fee schedule. So if you've got an attorney who's not filing that or not following that, you hope they're on the lower end of that. But I see a lot of attorneys trying to just flat overcharge note investors because you, quote, don't know any better. And that's just ridiculous. I like the Fannie Mae fee schedule. It's black and white. I can point to it and say, this is what the fee is. It has a built-in discount. That's why it's there. It's there because firms have a lot of Fannie Mae files, and Fannie Mae is the biggest player in the arena. At least they probably still are. And they kind of set the prices on this, and they work these prices down to, I think they're fair, but a lot of attorneys don't. A lot of attorneys think they're too low. So
are these costs recoverable as part of the plan, or basically your recoverable costs against the borrower?
That's a good question. Some jurisdictions, yes. Some jurisdictions, no. For example, Ohio, a proof of claim plan review, what I charge you for that is not recoverable. Some jurisdictions, most jurisdictions, it's completely recoverable. And then, of course, you got jurisdictions in the middle where even though Tony Sottile is going to charge you what Fannie Mae says Tony can charge, which is, I think it's either $900 or $950, I'm sorry, for a proof of claim and a plan review. I believe it's $950 actually. And then an additional $250 for a separate form called Form 410A, which is kind of a loan history. So it's upwards of $1,100, $1,200. There are some jurisdictions that say you're only able to recover $600 from the borrower. So now you can't recover that directly from the borrower if they're in bankruptcy. You have to file what's called a post-petition fee notice. Again, you don't really want to get too bogged down in this. We'll talk about post-petition fee notices a little bit on the PACER review. But you can't just bill a debtor in bankruptcy. You've got to go through the court to bill the debtor. And again, that's another thing that the attorney is going to know that the servicer may not know.
And that's a common mistake that I see, is when escrow goes up and so forth, you have to file something within like 45 days before, or there's a date before, because I'm going through that now,
Yep.
where the escrow got bumped up because the year just turned. So you have to notify the court that it's going up.
Yep, and we're going to talk about that. That's another common mistake coming up here.
Oh,
So,
okay.
so that's kind of common mistake number 2, and these are really in no great order. So this common mistake number 2, a loan maturing during a bankruptcy, that's a little more rare than, say, common mistakes number 3 and 3.5. We've got a bonus one in there. So let's talk about the first one. Common mistake 3: thinking that the bankruptcy filing slows everything down. Sure, it does. Okay, because it stops foreclosure, it stops your forfeiture action, stops your collection, whatever you're doing, it stops it. But to a debtor whose heart is pure, whose intentions are good, a debtor who wants to keep that property, this is how they can do it. This is how they can get that arrearage caught up. This is the kind of what you're looking for from a good, honest bankruptcy debtor. Somebody that wants to catch up those arrears and just need a break from the foreclosure action that's bearing down on them. And a good debtor, a debtor that means what they want to do, once those payments start, you've got a nice steady stream of income coming in. So if a debtor wants to catch up on arrears, this is a way for them to do so, rather than having to come up with a gigantic amount of money for a foreclosure sale to be canceled. They can file a 13 and pay that over some time. And in most cases, if there's arrears on a house, if there's arrears on property, that payment's going to come from the trustee. So the trustee in the case is actually the one doing a lot of the accounting on this. They are taking the money from the borrower, sending it to you, and you can look that up online. And it's a pretty good deal. So don't just think that because a bankruptcy's filed, it's going to slow things down for forever. It may help you out in the long run. But that leads right into 3.5, which is that you think you're going to get paid as soon as that bankruptcy is filed, because that's not the case, okay? So if the debtor is making the ongoing mortgage payments, that should continue pretty much despite the bankruptcy being filed. Could be a little delayed, a month, 45 days, maybe 2 months. But if that debtor's making payments, that debtor is instructed to continue making those payments. That's the ongoing payment. If there's arrearages, that's not going to begin until the plan confirms. So if you've got a property and we filed a proof of claim that lists $30,000 of mortgage arrears, it could be many months before you get that payment. Now, if the trustee is also making the ongoing payments in addition to the arrearage payments, okay, so that's called a trustee pays pre-petition, that's the arrears, and post-petition, which is the post-petition ongoing payments. If the trustee's paying that, you're not going to get paid until a proof of claim is filed, which you want to do right away anyway, but you got to get that claim on file. And in some cases, you may not get paid until that plan confirms. So hopefully the plan's going to confirm within a few months, but your attorney can help you kind of understand, because it's a guessing game for everybody here as well. An attorney can kind of give you some guidance on when they think that plan will confirm. And that would be based on objections to that plan or knowing that trustee in that jurisdiction. But you're not going to start getting payments just because that debtor filed bankruptcy. It's going to take a little while. But again, once they do start, they should continue.
Now,
so ways to speed that up, just real quick, ways to speed that up: filing that proof of claim. And if we have to, we can file something called a motion for adequate protection, which basically tells the court there's been your asset is depreciating, there's a diminution in value, and we want those payments to start immediately. We don't want to wait until the plan confirms. I would really only recommend doing that on higher value assets, because that motion for adequate protection is going to set you back probably $800, $900, depending upon your attorney. I don't think there's a filing fee for a motion for adequate protection, but you're looking at a lot of money when if you can just wait a couple more months, it'll probably start. So I wouldn't advocate for that. Yes, an attorney turning down work. I wouldn't advocate for that on a lower value asset. I'm sorry to interrupt, Chris. Go right ahead.
No, and I was also going to mention a few other things about getting paid immediately. What I've learned is the trustee gets paid first because they have, basically I think they get a fee or something for doing it. And then the other thing is sometimes there are superior liens above, the first mortgage. I've had sometimes, I think it was either taxes or, there's certain things that have taken superior. So I had to wait about 6 months before the payments actually started coming to me because I had to pay the trustee for 3 months. And then the payments, if it was $700 a month, will go into pay off some like tax or something like that. I've seen that happen in the past as well, correct?
Yeah, that's correct. And debtor attorneys get paid before you.
Yep.
Keep that in mind. Debtor attorneys get paid before you.
Remind me to tell you that I have a bankruptcy where the debtor's attorney was disbarred.
Ah, yes, that happens. Always interesting.
Yeah, they filed bankruptcy. The attorney had filed bankruptcy and was taking money from the clients and using that to defend her case and filing frivolous motions and claim that the trustee was basically incompetent, I guess, or something. It was pretty, I actually watched the hearing because my attorney said it would be entertaining. But
yeah, I would have said that would be entertaining.
Oh, sorry, interrupt. Keep going.
Nope, that sounds great. So these are just another couple of common mistakes. So kind of here's a fourth one. So what if there's a bankruptcy? I don't need to do anything. Oh, that could not be further from the truth. And I personally hear this a lot. Well, I don't care about bankruptcy. They want to keep the property. Well, that's a problem. That kind of attitude to get you into a lot of trouble. If you own it, that goes to bankruptcy. So these are some of the things you were saying before, Chris. So if it's a Chapter 7 bankruptcy, you must review that statement of intent. I'm going to show you what a statement of intent looks like on PACER here in a minute. But you must review that. You got to know what that debtor wants to do with that property. Now, this isn't a must, but you want to consider in a Chapter 7 context a reaffirmation agreement, which is a post-petition filing that your attorney puts together that they prepare, they send to the debtor's attorney, and presuming that debtor wants to keep the house, you would want them to file a reaffirmation agreement, which is just another promise to pay on a debt that would ordinarily be discharged in the bankruptcy. So in this case, what we're all dealing with here is property. So your lien survives. You still have a lien if that debtor gets a discharge, but you have no recourse against that borrower. You can't then foreclose on that borrower and go after them for the difference. You may not want to do that, but there's a lot of investors that do want to do that. So if you're able to get a reaffirmation agreement, that makes, in my opinion, your more valuable if you choose to sell it later on, because you can get a personal judgment against that borrower in a subsequent state court action and a foreclosure action. If that debt is discharged, if that loan is discharged, you can't. You're limited to just getting your property back. So again, something you may or may not care about. But in a Chapter 13 case, this is where there's a lot more musts, things that you must do. So there's a bankruptcy. Now you've got to jump into action. So you must review that plan and file a proof of claim. If you purchase a note that is not in bankruptcy, that then goes into bankruptcy, well, actually, we're going to cover that at the end. It doesn't really matter. But or if you're buying a note that's already in bankruptcy, make sure you're still reviewing that plan, even if you can't object to it, even if it's too late to do that. Make sure you review that plan and make sure there's a proof of claim on file. Like Chris was saying before, you have to file any ongoing payment change notices. So if the borrower's payments going up due to an escrow change, or a change in property taxes, an interest rate change, whatever it is, 21 days before that change goes into effect, whether it goes up or down, whether that payment goes up or down, you have to file with the court a payment change notice that says payments going up to X, payments going down to Y, and attach proof of what that is. So typically it's an escrow change, an escrow letter that says what the payment is going to and why. You can't just change the payment. This is a big way, note holders get into trouble is not filing payment change notices. Can't just raise or lower the payment. Now, obviously, you're not really going to get in too much trouble if you're charging the debtor less if the payment went down, but technically you're in violation of the bankruptcy code because you didn't file that at least 21 days before the change takes effect. So you must do that. You must file post-petition fee notices before charging the debtor's account. So we kind of talked about this with the recoverability question. So in the state of Ohio, if I charge you whatever I charge you for a proof of claim, you cannot file a post-petition fee notice, a PPFN, a post-petition fee notice for that money. But in Indiana, you can, okay? So if I do that same thing for you in Indiana, after I charge you, before you pass that charge along to the borrower, you have to tell the court, I have a bill here that I'm going to pass along to the debtor. It's $1,200, it's $1,100, it's right here. Here's the invoice from my attorney. I want it to be billed to the borrower. You have to file a post-petition fee notice in order to do that. You can't just add it to the debtor's account. You must respond to a trustee notice. So a trustee, if there's arrears on the case, and again, we talked about this, we're kind of talking high level, I'm glossing over a lot of things. When that trustee nears the end of the case, they're going to file a pleading called a notice of final cure. You must file a response to that notice of final cure that says, yes, I am the note holder. I agree that the debtor is current, or no, they are not current, and here's where they're behind. You have to file an agree or disagree response to that notice of final cure. Chris, you also talked about we were talking about escrow accounts before. A lot of times when notes are bought and sold, we're seeing on our end, on the legal side of things, we're seeing escrow accounts canceled or created. You can't just do that on a note in bankruptcy. You have to inform the court that you're doing that. So these are all musts. So don't think just because the property is in bankruptcy, you can choose to do what you want or what you don't want, because there's a lot of things you have to do. And then I've got that little line at the end. If you buy a note that's already in bankruptcy, kind of another thing you need to add, you have to file a transfer of claim. So, if Bob buys a note from Chris that's already in bankruptcy, Bob needs to file a transfer of claim so the trustee or the debtor who's ever making these payments knows to start paying Bob and to stop paying Chris. And that's called a transfer of claim. And that's another, you've got to file it. And then obviously still do everything that we've got listed above. So that's another big common mistake, is that people think they don't need to do anything.
And on transfer of claims, I used to rely on my servicer, but have found that sometimes they don't do it in the most timely of fashion or manner. And again, that's something that either a servicer or an attorney can do, but now I just go to the attorney because it's almost like they do 1,000 of these a day, it seems like. So it's like you just get in the queue and it's done, and very quickly. In that instance, I just found attorneys do it much faster and at the same price.
And Chris, you brought up a great point. Again, it's the pricing factor. Your attorneys are probably charging you the same amount that your servicer is charging, because behind the scenes, that servicer may be having an attorney do it anyway. So,
yeah.
And again, things like reviewing plans, filing proofs of claim, payment change notices, post-petition fee notices, transfers of claim. These are things that, and here's my pitch, that we can do for you in all 94 bankruptcy jurisdictions.
There you go.
But again, if not us, again, believe it or not, I don't really care that much. I'd love to do it for you, but the point is, you need to have that done. Whether it's me or it's somebody else, you've got to get those things done. These are musts for a bankruptcy case. So.
Yeah, filing one transfer claim for somebody isn't funding your trip to Hawaii. So
no, a transfer claim is $125.
Yeah.
I do them multiple times a day. Payment change notices, we file probably, I bet we do 150 to 200 of those a month in our office. These are things that we do all the time, every day across the whole country. So we know what we're doing. Kind of the last common mistake I wanted to bring up. This was at the behest of one of our attorneys. Again, this doesn't matter in a lot of cases, but it is a common mistake when it does come up. Broker price opinions, BPOs. A lot of people think that that's all I need when valuation is in question on a piece of property. Yes, BPOs are cheaper. In many cases, they're very cheap. And they're sometimes okay, but they're lacking when valuation is a big concern. This is very common in second mortgage cases, junior lien areas, not so much when you've got the first lien. But like we talked about, if the debtor doesn't live in the property, like we've talked about before, if the debtor doesn't live in the property, then they can cram it down. They can do things if it's property that they do not live in. So valuation sometimes matters. When I review a plan, I'm going to report back to you what they say the property is, even if it doesn't really matter. Even if I know you're a first mortgage, I'm still going to tell you what the debtor says that property is worth. If it ever comes into question, we need the best evidence we can on the value of that property. Best evidence is not a broker price opinion. It is not what Zillow says, what Redfin says, what the county auditor says. These are good indicators. These kind of values may help you with your due diligence, but these are not something that we can go before a judge and say, well, Zillow says it's $300,000 and that's the value of the property. So again, don't do this right away. Don't because the borrower files bankruptcy, don't go, oh my gosh, Tony said I got to go get an appraisal and it's $300. Don't do it until your attorney tells you have to. But just know the values in question, we're probably going to tell you you need to get an appraisal, and a BPO from 2 years ago is not going to cut it.
Tony, I have a question, then I have a comment too. One is, so if you're a first lien homeowner, is it possible to get a cram down on the value?
Generally, no.
Okay.
In a Chapter 7 case, no, and in a Chapter 13 case, no.
Okay.
That's if it's debtor-occupied primary residence property.
Okay.
The problem comes in if that debtor has multiple properties. They may list your property as being their residential property, but they may move from that residence. So these are all, this is why I need you to know the value that they're calling your property. If later on they say, oh, well, I don't live in that property, I rent that property out, then they might try to sneak in some kind of cram down, and we just want to be armed for that.
Okay. The other common mistake that I hear, and I'm curious if you see this happen a lot, is, people trying to reach out to the borrower when they're in bankruptcy, which is, I know, a big no-no.
People being the note investor, the
investor, yes, the investor.
Yeah, that's tough. It's real tough. You're not supposed to do that. They've got an attorney.
I've been told don't even consider it. If they call you, even just, tell them, basically run it through their attorney and have their attorney run it through my attorney.
You can give them factual information on the case. So if they want to know what is owed, you can tell them what is owed. Yep. If they say, can I pay in 2 months instead of next month? Talk to your attorney. When's the next time this is due? Talk to your attorney, because the date on the contract that says when the date is due may not be the same date as what the bankruptcy court says. So it's always best for them to have their attorney give you a call.
Yeah.
But again, I'm not stupid. I know that it happens. My institutional clients take debtor calls. It is what it is. That's just business. But don't get hoodwinked by what sounds like a well-meaning debtor and you're trying to help them out, because if that deal somehow goes south, or that debtor decides they don't like what you're presenting them anymore, they're going to go straight to their attorney and say, well, I've been talking with Chris Seveney and he said blah, 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 blah. And now you have a real problem, because now you're talking with a represented party in a federal bankruptcy case.
What would happen to me if I did that? Then, what's the ramifications, I guess, out of curiosity? Because I know you're not supposed to do it, but, what would happen if somebody did?
Well, you may not be able to participate in the bankruptcy, so you may not get your payments. You may have to wait until the bankruptcy's over with. More than likely, you'll just get hauled into court and get a wrist slap and told, don't do that again. So if that happens, don't do it again. But the ramification, I mean, you're not going to lose your lien. You're not going to, I mean, that has to be the most egregious case. You know, a well-meaning note investor, a well-meaning note holder, is not going to get a punishment like that.
Yeah.
More likely than not, you may have to go to the end of the line to get your money. You won't get your money until the end of the case. But then again, that means that debtor's getting to live in your property rent-free. And again, that's a pretty egregious punishment, but it happens to the big guys all the time. They lose their arrears because they're not doing the right thing. Again, probably not going to happen to the smaller guy, but it could. It could. You're going to avail yourself to the bankruptcy courts. You got to play by their rules.
Okay.
Okay, so that's just a few common mistakes. What I'd like to do for the next, I don't know, 15, 20 minutes is zip through some things on Pacer. So
that would be great, because I know a lot of people, basically, some people, if you don't know what Pacer is, it's basically I'll call it the catch-all for all bankruptcy, where this is when you're looking your due diligence for a bankruptcy case, this is where you go. So, and I'll let you, Tony, take it from here.
Okay, I want to pull up my, let's see if I can do this here. Okay, so
there you go.
That's my email, so let's get rid of that. Okay. Can I open up a browser? I don't know how I do that.
You should be able to open up a browser, and then at the bottom where it says share.
Okay.
If you clicked on
I know what I need. Yep.
Share, then it will let you select which browser.
Now I need to share, and there I
go. While Tony's doing this, people, if you have questions, feel free to put them in the chat over anything that we've gone through.
Okay, so here's what we're going to do. Talk about Pacer for a little while, okay? So, well, I want you to go to the regular Pacer screen here. So this is when I say Pacer, when you look up cases in Pacer, this is generally what you're going to see. So everybody can see Chris, you can see this?
Yep, and it's for people listening, it's pacer.gov is the website.
Yep, pacer.gov, and you're going to search for a case. So if you already know the case, you're going to do this bottom one where it's search individual court websites. So if you know you're going to go in and you know that the Smith case is in the Middle District of Florida, you're going to go straight there, okay? We're going to go back to that here in a second. But if you don't know where the case is and you're fortunate enough to have a Social Security number or to have a unique debtor's name, you can go in this way, okay? So it's going to default to the debtor's Social Security number, so you can type that in, okay? You can also search by party. Okay, again, your debtor's John Smith, don't even bother. But if your debtor is a very unique name, you might be able to get that. So you can put that in. You can choose a party role, which will further reduce your selections. And a debtor is DB, by the way, for debtor. So if you've got again, don't do John Smith, but if you've got a debtor's name, you know how to spell it, you know it's spelled correctly, go ahead and choose that DB feature right there. That'll weed out the CRs, that's the creditors. That'll weed out joint debtor. Well, maybe you not want to weed out joint debtors. It'll weed out U.S. trustee. We'll read out special parties and interest. And then the court type is bankruptcy. Okay.
And if you need a name, I've got names I can give you off the top of my head too, Tony. So
yeah, no, that's okay. That's okay. What I want to do here, though, to find a couple of cases that I've looked at earlier today, is I want to go back to the direct to a case, the individual court website. So I wrote down a case here that I'm going to pull up here. We're going to look at a Chapter 7 case first in the Northern District of Ohio. Okay, so you're just going to select that case. I've already logged in, okay? If you need to log in, you'll eventually make it to this screen. This isn't a hard screen to find. This is the kind of the main screen, and it's where you type in the case number. Okay. Now you're coming to this link in the Northern District of Ohio, in my case, in my particular example here, because you already know the case number. Okay. So we're going to put in a case number here.
And for those that don't, if you search by a certain name, like search Chris Seveney, there's only 2 of us in the US, and I had a BK, which I don't, but you typically, when your searches, it will show the case number, it will show the district, it will show the name, and I think it'll show like the date filed, and it'll show if it's closed as well. But it's kind of, and then you just click on any one of those and it'll probably open up what Tony's going to show us right now.
That's exactly right. So if you are searching for a debtor in the main search engine, this is the information you're going to get right up here at the top. Okay. It's going to tell you the case number. It's going to tell you the judge. It's going to tell you the kind of the chapter that it is. It'll tell you when the bankruptcy was filed. And this may be something that you want to know, because if your note originated after the bankruptcy was filed, or after the debtor's last bankruptcy anyway, then you really have nothing to worry about because you've got a good loan. And then there's a whole lot of things that you can look at in this Walters case here, okay? So the first thing that I always go to when I'm looking up somebody in Pacer is I go to a docket report, okay?
Good, that's where I go.
Okay, so I go to the docket report. I like to search by oldest date first, because I want to go all the way back to the beginning, okay? So this is what it looks like. This is a docket report. This isn't a very big one. Most Chapter 7 cases are not very big Pacer searches. You are charged to do a Pacer search. I think it's 10 cents a search. Yeah. Our Pacer bill quarterly is upwards of $15,000 a quarter. I think if your Pacer bill is under, I don't know what the number is, under $100 a quarter, you actually don't get a bill. Chris, do you know what the number is?
I think it's a little less, but yeah, rarely do I ever get a bill. And give people an idea, I have probably, I don't know, 8 to 10 bankruptcy cases going on right now, and I can't remember the last time I got a bill. And typically when you get the bill is when you're doing due diligence, not when you actually have the active, because what you're doing is you're downloading all these forms here. It's 10 cents a page with a $3 max. So if you've got 5 you're doing due diligence on, you may spend 10 to 15 bucks on each one, which it, will add up to 75 or 100 bucks. But you're right. It's, you need this, if you spend 10 cents, they're not going to send you a bill.
No, that's exactly right. So again, when you're spending 10 cents, just remember that Tony's Pacer bill is $15,000 every 3 months. So there we go.
and that's why it's $900 for a proof of claim.
That's one of the reasons. Yeah. Okay. So what I want to do while we're in a case like this is I want to pull up a bankruptcy petition. Okay. So it's going to tell you, actually, here's some good information. So it's going to tell you that the document you're going to request has 64 pages. You're only billed for 30 pages max, like Chris was saying. So the most you're ever going to be billed is $3, okay? Even though we're getting 64 pages. So we're going to go ahead and do this anyway. We're going to go ahead and take a look at this bankruptcy petition. We're just going to briefly look at some of these things in here. So
hey Tony, while you're going through this, and just so people know, this is all public record, correct?
Yes. That's the P. That's the P in Pacer, public.
So this stuff is, not anything like, oh, you shouldn't be showing this. Bankruptcies are all public records, so you can't get in trouble for like sending this without an NDA or something. It's all, this is all public record.
Correct. This is all public record. You're not going to get a debtor's social security number in this. Yeah. Certain things like that are redacted to only parties in the case. But yes, you can look anybody up. Like this. So this is, I purposely took some newer cases because the forms changed at the end of 2017, the beginning of 2018. So I intentionally took newer forms because you're going to see these more and more, and eventually this is all you're going to see. So again, this is a voluntary bankruptcy petition, a VP, a petition, whatever you want to call it. And see, they redact the social security numbers right there for the 2 borrowers. Not a whole lot on this first page. What I want to draw your attention to, for example, it'll tell you, have they filed bankruptcy within the last 8 years? so you'll know if they're a repeat filer right away. This particular debtor filed in 2015, and this is a 2019 case. So this is at least the debtor's second bankruptcy. So that may have some merit to what you're looking at with this borrower. They're multiple filer. Not a whole lot on these first couple of pages. Some people are interested in, how much do you estimate the liabilities, your assets. None of this really matters in my opinion. The real meat of this is when we start getting to the schedules right here. Schedules A and B, okay? Schedule A is all real estate, real property, okay? And vehicles. So this is where you're going to find, hopefully, the property that you're looking at. This is where the debtor is going to tell you in a Chapter 7 case, they think this property is worth $200,000. They say that they roughly owe $200,000 on the property. Again, this isn't factual. This is just what they think.
So, hey, Tony, just popped in my head.
Sure.
What if you have a borrower who files bankruptcy and puts property in there and your property is not in the bankruptcy?
Well, you're going to want to get an attorney involved because there could be a lot of reasons why it's not listed. Okay, it could have already been foreclosed on, and it could be listed in Schedule F, which we're going to talk about here in a second. That's why when you're doing due diligence and you're looking for a particular property in someone's bankruptcy, you got to look in multiple places. So first place you look, Schedule A, because that's where you hope it is, because that's a very obvious location for that property. Okay. It doesn't happen that they don't list properties and here's why they do that, Chris. Here's why, because their attorney says nothing's going to happen to your house. Don't worry about it. Your house is not part of this bankruptcy. So whether the attorney fails to list it or the borrower is doing this themselves as a pro se debtor, those are the worst. They don't include the property in their bankruptcy because they don't want to file bankruptcy on their property. It doesn't work like that. Every debt and every asset you have must be listed in this bankruptcy petition.
And that's what I did with mine. I went and got an attorney, let them deal with it.
Let them figure out where it is.
Yeah.
Because if it's not there, you've got to act quickly, because if that case discharges and you didn't do anything about it, you may not be able to collect on that lien. You may only be limited to getting your property back.
Yep.
You may not be able to do anything with that homeowner because that debt's discharged. Yep. So look on Schedule A. You can look at the cars. That's not that big of a deal, though. Once you get to Schedule B, well, what they do now is they merge Schedules A and B. So I'm sorry, I was a little confused by that there, but Schedule A is definitely where you want to start. Schedule D, don't worry about exemptions for this. Schedule D is where you want to be, right? So this is where creditors who are owed money on secured debt must be listed. So this is where you're going to see the note holders. This is where you're going to see the creditors, the car creditors. This is where you're going to see other lien holders listed on Schedule D. Okay, so we already saw from the debtor's voluntary petition page that they think the collateral is worth $200,000. Okay, that's where that is. That's where that comes from. They owe Bayview, or they say they owe Bayview, $182,500.
That's important. It's what they say they owe Bayview. You get the opportunity to tell them what they really owe you.
What they really owe. And you do that by the filing of a proof of claim. But this is a Chapter 7 that we're looking at. So we're not really looking at a Chapter 7 for purposes of filing a proof of claim or anything. We're just looking for some kind of financial information in a Chapter 7. Chapter 7s are quick. Chris, like you were saying, you don't even have a whole lot of Chapter 7s because they're done. They're in and out and they're done. Chapter 13s, and much of this is the same in a 13 as well, but Chapter 13s have some staying power. So, Schedule D is definitely important to a place to look for. Shell Point, obviously they might have a second mortgage here. So these are all things that you can look at a petition and maybe understand a little bit better. So Chris, you were talking about, well, what if your property's not listed? Look at Schedule E is kind of taxes and stuff like that, so it's not going to be there. But Schedule F is another place where people put their properties. People will put properties here if a foreclosure's been filed but not yet sold because they don't live there anymore. They've already moved out. The property was foreclosed on. Even though it's still secured and should be listed in Schedule D, they've listed it in F. So just because your property is not listed in D doesn't mean the end of the world. It could just be misclassified. And again, an attorney may need to get involved to get that changed, but in most cases, it's just not going to matter. So that's what Schedule F is. Schedule F is for creditors who have unsecured claims. So here's another bit of good information. Oh, there's a lot of debtors, a lot of creditors here. A lot of creditors. Let's skip through a lot of this. Okay, we're to the P's and it's in alphabetical order. So one thing that I really like that I want you all to know about is what you can find on Schedules I and J, especially if you're trying to help a borrower with a loan mod, or you're trying to do some due diligence to see if you could get a loan mod with this borrower. They have to disclose their income, their sources of income, and all of their expenses in these pleadings. Okay, so it looks like, in this particular case, looks like only debtor 2, this used to be husband and wife, but now they list them debtor 1 and debtor 2. So debtor 1, presumably the husband, is unemployed. Okay, it says he's employed and then it lists his occupation as unemployed. So you're going to find all kinds of mistakes like that, just the way that it is. But so what you're looking at here is really debtor 2 is employed. They're a cook at a middle school. Looks like they make about $1,500 a month. Okay, these are all of their expenses, or these are all their deductions still. Deductions really don't matter necessarily, but you're going to find what their monthly income is. Then the next schedule is their expenses. So you see they got a couple of kids in the house. The second debtor lives in the house, so it's probably a family unit. And then it lists their expenses. So somehow they don't have any rent. Maybe they live with a friend or something like that, so they're not listing any expenses for that. My guess is they're surrendering this property, but we'll take a look at that here in a minute. And you can look at their expenses here, right? So vehicle insurance, transportation expenses, food, lodging, all useful information to you if you are looking to somehow modify their loan. You can glean a lot of information from Schedules I and J. So I want to look at the Statement of Financial Affairs, SOFA, S-O-F-A. As everybody knows, everything's got an abbreviation in bankruptcy. So this is the Statement of Financial Affairs, SOFA. And this is going to also give you some good information, primarily, oh, they're a gambler. They won $9,200 gambling. How about that?
How much they lose.
Yeah, exactly. You will find, where is it? I think I passed it. Legal actions that they're involved in. Okay, so within a year before they filed bankruptcy, were you a party to a lawsuit? Have you been foreclosed on? Have your wages been garnished? You may find some information on an underlying foreclosure here that you may want to look up as you're doing some due diligence. You may not know that the property that you're looking at is already involved in a foreclosure, which you may or may not like. Depending upon what your investment goals are. That's what I really want you to look at in SOFA as you're looking at PACER. Look for those kinds of things. You got a 401k, so that's another source of some money. They don't have any balance in it. They've probably bled it down already, trying to not file bankruptcy. But if you see a retirement account here that's got a substantial balance, again, that may help you with a loan modification. Hey, give me a lump sum of $5,000. We can get this going. And I see you got a 401. I mean, you may not want to tell them that you're kind of stalking them and learning that information, but however you want to spin that with them, so they don't think you're a creeper, may kind of help your cause.
Because within a 401k, even if you're not of age, you can, for I think foreclosure, take a withdrawal. They'll allow a withdrawal for hardship withdrawal. Yeah. Hardship
withdrawals. And again, like Chris was saying, this is all public information, so you're allowed to have this. So this is the statement of intention the SOI, statement of intention, that I wanted you to look at. And I already see another mistake, because as you could, if you recall, when we're looking at Schedule D, they had mortgage debt to a couple of mortgage places. That should be listed here and isn't. So this is kind of a shoddily filed bankruptcy petition. You'll find a lot of crap out there. Those two secured creditors should be listed in here, along with what the borrower wants to do with that, which would either be to surrender the property, retain the property, and redeem it. That is not you. That is only for personal secured property, like cars, computers, rings, things like that. So you'll never see real estate with the possibility of redeeming it. That's a different kind of redeem than in a foreclosure context, mind you. Since we're looking at a Chapter 7, you're going to see retain the property and enter into a reaffirmation agreement. Again, this is something that you want to look for. Is there a reaffirmation agreement? If so, the debt is still valid. If you have a piece of property that goes into bankruptcy, see what the SOI says. If the debtor wants to do a reaffirmation agreement, they are good to do.
And that's interesting, Tony, because I learned this from discussion with you, is I bought a note that was in a Chapter 7. It was part of a pool of assets. But in here, they had selected surrender the property, but in the same token, they were still paying the mortgage and actually keeping it current. So, you know, when it got transferred to the servicer's like, what do you want me to do? There's no reaffirmation agreement. I'm technically not supposed to, you know, communicate with them and stuff. And I know I've seen some types of agreements be drafted by attorneys that basically say, you don't owe us anything, but if you basically want to send us payments, it's up to you, go ahead, but here's where you need to send them, essentially. Yeah, that's a hairy situation, I find, is when they say surrender, but then they keep paying.
And yes, so keep taking their voluntary payments, but don't call them when they skip a month. Just hope that continues. So
yeah, just have your attorney foreclose on it.
I'm sorry, go ahead.
And just have your attorney foreclose on it.
And then just go straight to foreclosure. Honestly, that's a case where you just go straight to foreclosure or forfeiture, or wherever you are with the kind of lien that you have. So in the interest of time, that's pretty much it for a Chapter 7 case.
Can you go back to the docket as well?
Yeah, let's do that.
You know, because in Chapter 7, just kind of walk through kind of the steps. Okay, they file it, and then I know there's like a meeting of, you know, creditors, and kind of, you know, like you said, this is about a 3 to 6 month timeline. And I've found in many instances just reading through this to see as well, because sometimes there might be, and it's usually more again on Chapter 13, a lot of objections and stuff like that.
So no, that's good. That's good. So just kind of looking at this, they filed bankruptcy on the 18th of January in 2019. Okay. That's when they filed that voluntary bankruptcy petition. On the same day, that court issued notice to the creditors, all the creditors that borrower listed, of when that 341 meeting of creditors is. Every bankruptcy debtor that files bankruptcy has a meeting of creditors. And that's, in this particular case, that was 3/19. So roughly 2 months after they filed bankruptcy. Other good things in here, you'll see some creditors filing requests for notices. So that just means that in this case, PRA, Portfolio Recovery Advisors, I think who that is. They're a big debt buyer out there. They just want notice of what's going on in the case. That's all that means. Employee income records. This might be a good thing for you to look at if this was due diligence for you. So you're going to hopefully on here be able to see the debtor's pay stubs. And that's exactly what we're seeing here. So this is notification of direct deposit. So this is what Ms. Walters makes. Now you saw what she had on what she disclosed on her schedules, but this is a pay stub. This is actually what she's getting. That's some good information. You're not going to see that in every case, but this particular jurisdiction allows, probably forces that to be filed. This is another good thing. After the 341 meeting of creditors, you're going to hopefully find this, a trustee's report of no distribution. Okay. That basically means the trustee has taken a look at the debtor's case and there is nothing for the trustee to take, liquidate, and give to creditors. That means this case is going to wrap up pretty quick at this point. And it should wrap up within pretty quick here. So this one wrapped up very quickly. This one wrapped up 2 days. The discharge order was entered 2 days after the trustee filed that final report. But what's interesting is that 341 meeting was held. It was continued to 4/2. So the 341 meeting was held on 4/2, but the trustee didn't get around to filing their final report until 2 months later. Okay. That is just the way that it is sometimes. Usually what you want to see is these reports filed pretty quickly after the 341 meeting of creditors, but sometimes it just doesn't happen like that. So look for that. When you see that, you know the case is kind of nearing the end. And then you see that they got an order of discharge, and the case is closed a couple of days after that discharge order goes on. This is a very common Chapter 7 case. This is probably how the vast majority of Chapter 7s go. They file, there's a 341 meeting of creditors, they get their discharge, case is closed. Not a whole lot of activity.
And Chapter 13s can go many different directions.
Chapter 13s go many different directions. So I'm going to pull up a pre-arranged Chapter 13 just to point out a couple of other things to look for in a Chapter 13 case. Again, I'm going to go straight to the docket report. Look at the oldest case first. And again, you see, first thing filed, it happens to be the same amount of pages, I think 64 pages, is the voluntary petition. So I'm not going to pull that up. We don't need to look at that in a Chapter 13 case, since we just looked at one in the Chapter 7 and they're the exact same. What I want to call your attention to in a Chapter 13 case is a filing that's typically filed the same day, and that's the bankruptcy plan. By law, it has to be filed within 14 days of the bankruptcy being filed, but typically, because debtors' attorneys use a lot of software that help them with these filings, because they're pretty voluminous. They're typically filed the same day. So let's open up this Chapter 13 plan and take a look at a couple of things here. Okay. First thing I want you to look at is Part 1, the notices. Okay. If in 1.1, if they check this box, this included box in section 1.1, that means they're trying to limit what is paid to a secured creditor. That's you, okay? So if this box is checked, if the included box is checked, they are trying to cram down something. It might not be your loan, it might be the car loan, it might be another piece of property, something like that. But this is your first indicator that something would be potentially wrong with your case. In this case, they're not trying to cram anything down, okay? The other thing you want to look for is non-standard provisions, and we're gonna look at that at the end here. Actually, Chris, this is another good thing that we can do in a couple of months, is a real deep dive in a Chapter 13 plan. I could spend an hour on the plan alone.
I was going to say, I think we could, because you can get into, I mean, just going back to looking at some of the other things on here, just to see if the claim is on there, or if, you know, because sometimes there's multiple claims by the same company. So it's like, okay, which one am I buying? You know, so there's search through there. So yeah, we could definitely do a follow-up deep dive on some other components of this.
But while we're here on this case, look to the treatment of secured claims. Okay, that's exactly what this part is called. Part 3, treatment of secured claims. You can't really see it, but this is real property right here. Okay, this is where, so if you're looking at purchasing this loan, or this is your name potentially, or the name of your company, make sure that the current payment amount is correct. Okay, make sure that if you are owed arrears, that this arrearage figure is populated. Okay, these are all things that when you send this to your attorney to do, I do look at this. I look at this and I will report back to you. They say the ongoing payment is $676.64. They say there's no arrearage. If any of this is wrong, let me know.
And for people who just confirm, arrearage is basically past dues.
Past due,
Yep.
all the way up until that
So-
bankruptcy was filed. Anything due on that account is listed as an arrearage in this petition.
So that could be advances if you advance taxes, or, you know, interest for payments missed. It's, you know, it's a lot of things, but it's basically, it's really a lot of times the difference between the UPB and the total payoff essentially is, putting it in a simple terms, kind of what it is.
Yes, there you go. Okay, so you're going to look at the treatment of secured claims. Look at, remember that box we talked about at the very beginning? If there's any kind of cram down, you're going to see that here. Hold on a second. Let me look ahead here. Okay, you're going to see that in here, but because there isn't anything to be crammed down, it's not here. There's a surrender of collateral section. Okay, your collateral could be listed here. This is the debtor's plan of reorganization, what they intend on doing with your property. So these are the places where you need to look. There's a lot of stuff in here that really doesn't matter to you. You don't really care how much total debt they have. But the other thing I want you to look at is the non-standard plan provisions, okay? This is another area where our firm spends a lot of time when we're reviewing plans, because this is where they're going to say, I owe Seveney Investments $50,000. I'm going to pay them $1 a month until month 59, or I will pay the balance of what I owe. Okay, now that sounds ridiculous. I see it quarterly. Some kind of ridiculous non-standard plan provisions. But here's the problem: if that is listed in the plan and you have proper service and you don't object, Seveney Investments is only getting $1 a month for 59 months. And then you better hope in month 60, they're going to pay the rest of that off. And we all know that that's not going to happen.
Yeah. I have one where we did object because the borrower makes $20,000 a year, and it started out for, like, in the arrears are, call it $60,000 for easy rough numbers. It was starting out at like $300 a month for like the first 24 months. Then it goes up to $2,000 a month for 12 months. And then the last 24 months is like $2,500.
Yep.
And my attorney's like, the guy makes 20 grand a year. How's he going to afford $2,500 a month? The judge, after we objected twice, basically still would approve it. So my attorney's like, stop fighting it, because you're not, I mean, just now you're basically just let them approve the plan so they can, you know, they'll fail faster essentially.
Or you'll start getting, at the very least, the $200 or the $300 a
Yeah.
month you're supposed to get for a little while.
Yeah, which we got that. Now it's starting to kick into that next amount, which we know we're not going to get.
And if you don't, then you file for relief from stay.
Yep.
But at least you've gotten some money coming in.
Yep.
But that's why you need an attorney involved in a lot of these cases.
That's important
hey,
for people because, like you said, Tony, you know, you're going to see everybody and their brother try and stick something in there. And
yes.
a lot of people just glean over these things. And it's especially when you're doing due diligence on a note you're buying and it's possibly a hedge fund who kind of just, it was a low balance bankruptcy and they weren't paying attention, because you see that a lot too, because it's not worth their time to pay attention. So definitely something to look at as part of due diligence.
A Chapter 13 PACER is going to be much larger. This case is still ongoing. So this case is an active case. So there's nothing really recent. So this is a good case. This debtor is clearly paying, and there's not a whole lot of action in this case. But what I wanted to point out is what you can find on here. So even though this is for a vehicle, this motion for relief from stay is for a vehicle, and you know it's not your property, this could be your property. So if you're doing due diligence and you see a motion for relief from stay and then a subsequent order granting that motion for relief from stay, that's going to change how you look at that property, because now that property is not part of that bankruptcy. That debtor does not want that property. So now you know you're not getting any more money in that bankruptcy. So money's out, and now you've got to file. You've already got relief from stay, so now you've got to go into state court and file for foreclosure. So you can get a better idea maybe of what your potential legal fees are on a case, to help you price your offers.
Yeah. Once you get the motion for relief, Tony, basically you ain't getting any more money from that borrower. You're basically, it's done, correct? Your
That's
only
correct.
recourse is BK?
Yeah, if we go the motion for relief from stay route, we're doing it because you're not getting any more money. So if that debtor wants to now pay you after we filed for the relief, you have two options. We can either withdraw the relief from stay, or you can, and then you can accept the money, or you got to send the money away, which is tough, but you can't have it both ways. You can't ask for relief and also take money. So motions for relief from stay are kind of your last effort. You know, they're not paying. So now, that being said, if you file for relief and they come to you with some money, or their attorney comes to me with some money, I'm going to go to you and say, you know, hey, look, maybe there's a way we can get both. We can get that money and we can protect ourselves against having to do this later on. And we can reach an agreed order that says, okay, the debtor fell behind $3,000 after the filing of the bankruptcy plan. We will take $500 a month for the next 6 months, in addition to the ongoing payment, in addition to the arrearage payment amount. So it's kind of snowballing, as you can see. Okay, but it gives that debtor another chance, and it allows you to keep the money that's come in, that came in after we filed that motion. Then if that debtor falls behind again, we can go to the court on a more fast track method called a notice of default, and say they've defaulted on the agreed order that we entered into, and it saves you some money. You don't have to start all over again with another motion for relief from stay.
Tony, one thing, if we get a few more minutes, could you show people the proof of claim?
Sure.
Just because I know that's something that you know, we've been talking about. And I think it's important for people to kind of visualize it so they can kind of see.
So you can look at a proof of claim by going to the claims register. And I didn't happen to see if this debtor had real estate. Oh yeah, we did, and they do. Yeah. So here is a real estate proof of claim. Okay, so this is a real estate proof of claim. Okay, again, looks like every other bankruptcy form does, kind of laid out the same. It lists the value of the property. I actually don't put values on my proofs of claim because you don't need to. But what the big area is, the amount of the claim that is secured. So that's what you're going to put there, what you're owed. You're going to put how you're perfected. So it's going to be, you know, note secured by mortgage. Different language is kind of commonplace, but this is the amount of your claim: $121,658.53. Okay. If there is arrears, you're going to put the arrears right here, but this debtor is current according to this. Okay. And then this is the form called the 410A form. You see that right there, 410A. And because they're current, there is nothing on here. The only time you're going to have something on a form 410A is when there's arrearage. And then there's attachments to the proof of claim. So there's going to be the note, the mortgage, an escrow statement. All of those things are then attached to the proof of claim. That's filed. But here, this particular proof of claim has a notice of mortgage payment change attached to it. So at some point during this bankruptcy case, the payment changed. So the creditor went in and filed this notice of mortgage payment change. And the current escrow was $68.50. And the new escrow payment was just going to go up a couple of bucks. But to make that happen, and this was going to be effective on April 1st of 2019. In order to make that happen, they filed this a month and a half in advance. They filed this in February of 2019. You have to do it at least 21 days in advance. That, I think, is even listed on here. Yeah, must do it 21 days before the new payment amount is due. And that's the notice of mortgage payment change. And here's why it changed. The creditor attached the escrow disclosure statement that says where it changed.
And sometimes you may miss filing it in time, and you basically just have to wait till you can start charging them that escrow. It's not like, you know, not like the end of the world. Just, you know, I've got one right now that my servicer was supposed to give me it was for March 1st, and on February 10th, they were supposed to, you know, or February, whatever, they were supposed to give it to me, and they missed it and gave it to us a day late. And it's like, oh, now we got to wait till April 1st.
Yeah. So just rerun escrow.
Yeah.
The payment will be a little bit different again, but you'll be able to recoup that.
Yeah.
You just can't recoup it that month, starting that month.
Yep.
Again, I mean, we could literally spend a lot of time looking in Pacer. So Chris, let's something that we don't need to do it now, obviously, but you know, sometime in the next few weeks, let's set up something for, you know, later this spring where we spend the whole time in Pacer.
Yeah, we'll just, I mean, grab one case and just kind of go through the entire thing. And, you know, if you want, Tony, we can use one of my cases even, because I know the history of it. So I can kind of tell you what was the back and forth that may have led to one thing or another thing as well. Be happy to go through that. And because I've got, you know, some pretty interesting ones. It seems like, you know, I always get these whacked out crazy ones.
So that's, I mean, that's kind of a nice little, probably more of a overview than a deep dive, but I think we're trying to be a little aggressive with doing both of those things tonight.
Yep. And one other thing too, Tony, mind just clicking on the history documents, because that's kind of another, you know, tab as well that is very similar to that other report that you show, which kind of, again, just goes to the history. Now on chapter 13, I think this one had like 32, 32, I'll call it numbers. Those can get up into the hundreds pretty quickly.
Very quickly.
So, you know, this one's kind of a short one. So
this is, and that's exactly right. So this is just really a boiled down version of the docket report.
Yeah. So, and like on this one, just, oh, you mind going back?
Yep.
Like I scan this in because I see like things like number 8, pay mortgage outside of plan. I would want to take a look at that. You know, return mail stuff I don't care about. The financial course I don't care about. You know, dockets of credit cards and stuff like that. You know, transfers of claims really, unless it's yours, you don't kind of need to worry about. And you'll start when you go through these things understanding what's going on. And if it's yours, you're going to know what a lot of this stuff is because your attorney is going to tell you, you know, all these things already. But the other thing I believe, Tony, correct me if I'm wrong, like when you see a motion for relief from stay, to understand what that is, if you go back to the claims register, that would attach to whoever's order of the motion for relief that was, correct?
Yeah, there'll typically be a trustee note on the claims register that would say relief obtained. They're not going to be paying it anymore. So this was the mortgage creditor here, claim one, claim one. It would just be, you know, somewhere probably in the remarks, the trustee would go in through the court, say relief granted, you know, it's not being paid anymore.
Yeah. So yeah, so you can see here, there's only one thing associated with that. You can kind of see, you know, amending claims for some of the other ones and stuff, but we'll go through a deep dive on those again later on another time.
We'll call it a deeper dive.
Yeah, on a deeper dive, because, you know, I find for bankruptcy, you know, I like them. And when I say I like them, I like to buy bankruptcies that have been, you know, 12 to 30 months in bankruptcy, because a lot of those instances, the borrowers, you know, if they made it kind of a year plus in the bankruptcy, they start to see the light at the end of the tunnel, and they've been making their payments. And you got to remember, these borrowers, after 60 months or whatever the period is, any credit card debt, all that's gone. So they've got no bills except the mortgage to pay you. So, you know, should keep paying you after that, because they're also not going to be able to go out and get $100,000 in credit cards again. So that's one thing where I say I like bankruptcy. I like to acquire, you know, assets that may be in bankruptcy that have been in bankruptcy for a little while.
And there's a lot of folks out there. There's a lot of folks out there like that. So it's a very common. I wouldn't say very common. It is a sound investment strategy.
Yep. Okay, anybody have any questions? I think we just probably blew everyone's minds
Got
on as you start, because, and this is one of those things, I'll be honest with people, if you go into Pacer and you're not familiar with it, the first few times you go in there, you're going to be completely lost, in the sense of, it's like, oh, how do I do that again? Type thing. But once you start, getting a few assets under bankruptcy and stuff, you learn really quickly. It's like, okay, here's what I'm going for. But every time you'll learn something new, because you'll be doing due diligence on a case and realize, what is this? And that's, again, I reach out to Tony sometimes, like, Tony, and I'll download that form and be like, Tony, what is this? And, get an answer from him. So.
Yep. We do our best.
So good. Tony, any last second thoughts on anything?
No, just, thank you for the ability to come on here and spread some knowledge about bankruptcy. It's a confusing topic. It's an attorney heavy topic, but we can get through it together.
Yep. Well, not take up any more of anyone's time. Again, thank you everyone for joining us for this episode of the Good Deeds Note Investing podcast. And again, go out and do some good deeds. Thank you all.